But that is not the only case that you have won recently, right?
Right. We won a case in Montgomery County Circuit Court, State Court. Montgomery County, after Bruin was decided, oh my God, we can't have this. So they did in New York or in New Jersey and said, we're going to enact a local ordinance that said, you guys with permits are no longer going to be exempt under our statute, which was the current law. You're going to be subject to everything. And we're going to define sensitive places to include every place within 100 yards of this list of 15 places. And the 15 places includes churches, private schools, regardless of whether the property is privately owned or publicly owned. And on the literal language of the ordinance, it doesn't even matter whether the place is otherwise open to the public. So in one of the places, for example, that was banned is a library, privately owned or publicly owned library. And if you have a private library, and I'm sitting in one right now, well, arguably that's a prohibited zone now. Now they made an exception for possession inside the home. I mean, actually inside the four walls, not on your property. Maryland law allows you to possess a handgun without a permit on your property, real estate that you're actually on, but not Montgomery County. It has to be within the four walls. So if you stepped outside your door onto your property, you could be in violation of this ordinance. And then they have this 100 yards within all these places. And if you look on a map, and you use Google Maps with this, you can identify all these places that they have, and there are thousands of them. I mean, literally, there's 693 parks in Montgomery County. And they range from 6,000 acres to a city block. There are 695 churches and places of worship, all of which are banned. That means the synagogues that have been using permit holders and to actually provide security and have been given permits on that basis by the Maryland State Police back before Bruin was decided, are now incapable of using these individuals to provide security. In fact, they couldn't even carry themselves on those places. So that basically leaves synagogues and churches naked from a self-defense perspective. And you don't have to be very sophisticated to understand that's a problem.
And Montgomery County, for anyone who's not from Maryland or the area, that's the largest county in the state, right?
It's over 1 million people, the largest by population in the state by far. It's got a $6 billion budget.
It's just outside of Washington, D.C. So
it borders Washington, D.C.
A lot of people live there. And additionally, at arguments in this case, at least from what the judge wrote in his ruling, it sounded as though the county admitted that there basically wasn't anywhere you could legally carry a gun, even with a permit in the county, right?
Well, what they admitted was their intention was to make it impossible to carry with a permit. And that's quite true, because you literally could not carry very far without running into one of these 100-yard buffer zones. Like, for example, the buffer zones included most of Interstate 495, which is the beltway around D.C., most of Interstate 270 going north from D.C., all the major thoroughfares in urban parts and most of the rural parts, minor roads as well. But you can't get in and out of the county without covering a buffer zone, because so many of those portions are covered with parks. So it was basically intended to, and did quite successfully, make it impossible to carry with a carry permit. And what the
so a very big impact there. I think there was also a ban on the possession of unserialized firearms.
Yes,
that you make it, homemade guns, ghost guns, it was called,
and components, by the way, which they defined to mean the barrel of a long gun, the slide or cylinder of a handgun. In other words, if you could take your serialized handgun, bought at an FFL, perfectly legally, and break it down for cleaning, all of a sudden you have a prohibited component.
Right. Because it doesn't have a serial number on the barrel.
And that's, of course, not a firearm under federal and state law. Right. Those components aren't. And they reserve the exception to the home exception to firearms. So you literally couldn't possess a component in your home under the literal reading of the ordinance. I mean, that's how ignorant Montgomery County is about federal firearms law.
Yeah, so a very poorly written ordinance. But I guess this was blocked by the judge, not on Second Amendment grounds, but on state preemption grounds. There's a law in Maryland that says localities cannot make their own gun laws, that it's a state, the state has to make them. Right, that's the basic ruling.
There is a broad preemption provision, and there are exceptions, which is what the county was relying on. But separate and apart from that, that's provision, which is a broad preemption. There are 5 other statutes which broadly preempt local regulation of regulated firearms, which in Maryland are handguns, and broadly preempts localities from regulating the transfer of long guns. And there is also in Maryland law a implied preemption where if the state has a comprehensive system of regulation, then the court will apply a preemption of local regulation to the extent that it attempts to regulate in that area. And the judge found, and quite correctly, that Maryland has an extremely comprehensive system of regulation of all kinds of firearms, long guns, handguns, you name it. So it was not hard for him to find such a comprehensive system, nor was it difficult for him to find, with all these existing laws on the books, that the Maryland law, the county ordinance, that is directly conflicted with it. So that was the basis of the court's ruling.